sense that, you know, you just moderate your claim about when and where you can exercise unilateral authority to target people for that. Yeah, and maybe that's the answer.
All right, so let's hear from the audience, yes.
Hi, Martin, you lamented the president, or what I understood you to be lamenting the president's failure to avail himself of the bully pulpit in order to establish the parameters of the debate. And Steve, I heard you saying that, well, he's kind of naturally limited by whether or not he thinks Congress is there to back him up. I want to throw out two other theories of limitations on his ability to use the bully pulpit and wonder what your reactions are. One, he didn't fire enough people in enough middle and high places when he came to office. For example, you know, why is Gates Secretary of Defense? Number two, which is perhaps a little bit more controversial, but came to me because there seems to be such a groundswell of, you know, even now remaining opinion that, you know, he was born in Kenya and that he's a Muslim. Is it also possible that he woke up one morning and said, "Holy shit, I'm a black man who's president of the United States"?
Well, Gabor, those are not at all sensitive. So I think your second point about timidity, right? Because I mean, both those points are about timidity, right? And I guess query what would have happened if we had killed Osama bin Laden on January 24th, 2009, right? If early in the administration the president had developed that much national security credibility and could sort of take it out first pick. I mean, I think there's no question he was inclined to tread lightly. But then the irony is, why issue the executive orders, right? Why issue the closed Guantanamo executive order, right? Why issue the treatment executive order? Why issue the transparency and declassification orders? I mean, you know, so if he really wanted to be timid, his mistake was not being timid, right? By actually staking out these fairly broad policy goals and then abandoning them or not living up to them. On the point of not firing enough people, I think there's a lot to that. I think in this room it's also not getting the right people confirmed. If I can say that, right? Because I mean, you know, you don't need national security as an example to know that interagency fights in government are usually won by, you know, the heavier hitters, right? And so, you know, when you don't have that, when you don't have confirmed heads at the division level in a bunch of the DOJ divisions, you know, they're gonna get walked over on by the White House, and that's, I think, what happened on a lot of these issues. So I don't think it's that he didn't fire enough people. I think it's that he let the Republicans get away with way too much obstructionism and not confirming the right people, where we might have actually seen more of this. And this is not a problem just in national security cases. I mean, this is a problem in healthcare cases. You know, the Medicaid case the court heard in February, the Douglas case, right? You know, why did DOJ file this horribly anti-HHS brief, right? They did it because, you know, they didn't have an SG confirmed at the time who was actually fighting to defend HHS's position, and the White House, you know, didn't care, right? I mean, so I think it's not just his timidity. I think it's also his unwillingness to fight early for the territory that mattered, right? And you know, if you want another example, Judge Ships. I mean,
So is that Rahm Emanuel versus Greg Craig?
maybe. I mean, I wasn't there, right? I just, you know. Certainly that's the narrative, right? I mean, certainly the narrative is certain people in the White House beat out other certain people in the White House, and you know, I think maybe we didn't have. Dawn's going to punch me for this, but I think maybe there could have been different people in the different positions in DOJ who might have produced a different result in some of these issues, including, I dare say, the SG.
I don't think he fundamentally changed, though. I don't think he woke up and thought anything different. You know, I don't think. I think if you actually look carefully, which I'm sure you have, yeah, at what he said in the campaign, that part of the problem is the expectations were wrong for the kind of president he would be.
Yeah, I mean, I guess I see it, and I could be completely wrong, less as a matter of, you know, race than as a matter of foreignness, if we're talking about it. So if it were Colin Powell and he really wanted to, you know, do something, I think race would have been much less of a problem. I think and this is just sheer kind of politics now, speculation, that he had this approach of trying to, unite and transcend differences, etc., which, in retrospect, looks rather naive given, the Republicans and the Tea Party and all of that. But I think that had a lot to, so, he was elected with certain commitments, like Guantanamo, and those he took decisively. But then beyond that, he wanted to sort of, not ram things through, build a consensus, and transcend the kind of blue state, red state thing, and found that, put most of his eggs in the healthcare basket, got that, but that was incredibly tough, and just couldn't do it.
Healthcare and 2 Supreme Court justices.
And 2 Supreme Court justices, right.
Any kind.
And then in terms of appointees, State Department, pretty good, right? I mean, Mike at DRL, and Anne-Marie Slaughter, and policy planning. Harold, Office of Legal Counsel. I'm sorry, legal advisor. But then what do you make of, and Harold in fact says, look, my client is the executive branch, or my client is the United States, and things are different when you're a law professor as opposed to, counsel for the government. And that was one way he has explained taking a position that at least he's hinted he might not necessarily have taken, had he been still at Yale.
On the question of leadership and executive power, do you think the president might have made a mistake in announcing on day one that he was going to close Guantanamo rather than quietly moving the Uyghurs to Northern Virginia? Did he make a mistake in announcing that the 9/11 trial was going to be in New York instead of moving the defendants to Manhattan and then announce? More leading by doing within the constraints of the power that he had.
Right. I mean, I would myself amend it, and these folks would know more, whether what I'm going to say was practical or not. That not to announce something early, but not to announce it until everything was in place to do it very quickly. And my impression is what he did was, announce it without kind of thinking through, how even if he did it unilaterally as president, what the difficulties would be.
So I guess, let me try to defend, I think I agree with the meme, but let me try to defend it, right? So JFK said, in his inaugural address, right? We're going to put a man on the moon in the next decade, right? He had, if you know the story, right, he had no clue, right? There was no report that said it will take exactly this many years to develop the space program, right? Why did he do it? He did it because he wanted to set a goal, right? He wanted to push people toward the goal. So, I think sometimes presidential leadership is staking out a very, very highfalutin claim and then expecting that you're going to find a way to get there. I think the trick is knowing when it's the moon and when it's Guantanamo. What's easier to get to?
Yeah, right. Or what's easier to get out of.
If you're trying to close Guantanamo and not put a man on it, if you're facing a Congress, an opposition party that has sworn to do everything possible to oppose whatever you say and to defeat you the next time around, coming out on day 2 and signing those 3 great executive orders, I was thrilled when that happened. Almost seemed to put a big kick-me sign on the president's back for that issue.
I think the president may have miscalculated his inability to get anyone to cross the aisle, right? I think at least in 2009, the idea that there wouldn't be any Republicans who would cross the aisle, I think was in retrospect a huge tactical mistake on their part.
So I don't want us to forget the role that Dick Cheney was playing in unprecedented criticism and threats to the president-elect. And I wanted to ask you about, whether or not Chris Edley's drop, saying that there were real fears and real intimidations about a military coup, how much that might have inhibited Obama from moving forward, especially in the area of accountability.
Can I ask people to identify themselves?
Sure, I'm Hazel Weiser. I'm the executive director of the Society of American Law Teachers.
I'd leave it to the Beltway people.
Oh,
For,
right.
I mean, I find genuine concerns about a military coup, a wee bit far-fetched. With regard to, Cheney, I'm not sure, Cheney either during or immediately after the election. I mean, that might have been an asset to Obama, to a certain degree, because I think Cheney's, Q rating at that point was so low, even before Bart Gellman wrote the book, that at the very least it was a wash in terms of Dick Cheney saying something in terms of constraining what Obama was going to do, would be my impression. But then again, I don't know the inside of government. I'm just the human rights guy who kind of keeps pointing their finger at government from the outside, so I'll leave it to...
I don't know either, but why should that stop me from talking? All I'll say
professor, after all.
That's right. All I'll say is I actually think this dovetails with Gabor's question about Gates, right? I think the two agencies that the president was really worried about, sort of, looking like he was not threatening, were DoD and CIA. And I think that's why he kept Gates, and I think that's why you didn't see a lot of top-level firings at the agency as well. And I think it's hard to say. I mean, it's hard to say that because the butterfly flapped its wings over there, that caused all these other things. I mean, I think it's all sort of endemic of a larger problem, but I don't know that anything in isolation caused anything else in that regard. I think it was a very deliberate choice by the president to not to preserve continuity, right? I mean, that's where I think Jack Goldsmith is wrong, right? It wasn't about substantive continuity, it was about leadership continuity, which actually might be that much more powerful if the policies really changed.
I'm Jack Mackenzie. I used to write editorials and bold your opinion, but I don't do that anymore. I wrote a little book about the unitary executive, which absolutely demolished the whole thing. Nobody's talking about it anymore. It's a small book. If it's still available somewhere. But Charlie Savage really set the stage. And I'm sorry I didn't hear your whole introduction, because I want to say that his book, which is a great book, never said the millennium was going to come with a change of administration. He never said that presidents, that a better president would do a much better job. I think, I mean, having talked with him about it, I think he understood that presidents don't give up power very easily. But Charlie is a great monitor, and that he shows it that he's on the case, and that's just a terrific thing to have happen. I'd like to take an easier case and get away from some of this foreign policy stuff. I'd like to say the recess appointment thing. That's a separation of powers. That's a balance of power thing, and Obama was just bone stupid to fly and to make a recess appointment when there was no recess. It's one thing to do it when there is a recess, but it was really, it's a loser. It's just a logical loser. Why pretend that it's not? Why pretend that he's a brilliant constitutional scholar when he does things like that?
So I think that Congress has created a situation where there are not recesses. That's the problem, and it's like the filibuster, and so we have a real political problem where Congress is not living up to its constitutional responsibilities, I don't think, and we have the president in that context aggressively exercising his constitutional authority to make a recess appointment in a situation where Congress, the Senate, is trying to prevent him from ever being able to do that. I think it's a difficult question. If you read the OLC opinion saying that he had the authority, I think it's a strong opinion, but it's a close question, and it's going to be litigated.
There are real recesses.
Not anymore. I mean, not
Well,
anymore.
well,
They have
between-
structured
between-
it so that every
between
3
sessions of
days they
Congress.
come back into
Even
session.
even the intersession recesses aren't really recesses anymore.
Right, right.
Yeah, they're trying to make it impossible. And so what do you do then? And what is a court going to say when they get that?
And they're not confirming anybody, so.
Well, but I
And
think-
they're not confirming anybody, combined with the filibuster
And I
threats.
think this goes back to a point we were talking about before, right, about this administration's reluctance, borderline paranoia about making strong Article 2 arguments, and I think it says something that this is where they finally decided. Right, because I think that I have to think that this was a long debate within the administration about whether this is the right place to actually make the strong executive power claim, and I think they felt so vindicated by the evidence that Congress was up to no good, that they thought if this actually ever got to court, they'd win.
Yeah, I haven't looked at this issue in a while. I mean, there's a part of me that wants to, is counter to what I usually go, that this is a case of kind of two wrongs making a right in terms of separation of powers, insofar as ordinarily the story of separation of powers is the executive branch is just this bloated gargantua compared to, you know, what the founders thought. And so if we're worried about balance among the branches, you know, as a key idea of separation of powers, of course you should be for things like legislative vetoes, and of course you should be for things like congressional control over removal, or at least putting strictures on removal and all of that. That's kind of usually the thing I argue. But this is an instance where you've got, maybe it's a two wrongs making a wrong. Congress, in trying to control the executive, now is resorting to not approving executive appointees at all. Now, is that political, or is that, you know, with regard to Obama, or is that just something Congress is resorting to because the legislative veto's gone and, you know, removal checks are gone to an extent? You know, I don't know, but if you view it as an attempt by Congress to check the president, the problem is it's almost too effective, and it creates, you know, it is too powerful a check on the president. And so ordinarily, while I'm for sort of modest calibrated checks on the presidency, this one goes too far, you know, would be the way I'd analyze it.
All right, we have time for one more question. Who has the, yes, thank you.
Well, if I could just piggyback on that, on this discussion, you know, in the case of the recess appointments, among others, we're not just talking about sort of a mid-level or even a high-level official here or there. We're talking about Congress's campaign to shut down the National Labor Relations Board.
Right.
And when you have that going on next to Congressman Issa subpoenaing the records from an ongoing litigation brought by the agency, you know, out in California, out in Washington. I mean, what's the reservoir? What is the check when Congress is challenging the operation of an entire agency in that way? Is there one?
So I mean, I think there's, and I think this is maybe a fitting place to try to tie things together,
Yes.
right? Because I think there's a hard question, right? Should progressive executives be leery of strong executive power claims, right? Especially strong executive power claims vis-a-vis, right, against Congress, as opposed to just without Congress. And I think the problem is that we feel like the reaction of the Bush administration has to be yes, right? They were wrong because they were defying Congress, right? But I think there's more to it than that, right? I don't think it's just about what is has Congress acted. I think we have to ask, what was Congress doing, right? So the statutes that were at issue in all the Bush administration cases were constraints on the executive, right? Were individual rights protecting statutes, right? The Non-Detention Act, the Anti-Torture Statute, the exclusivity provisions of the Foreign Intelligence Surveillance Act, right? I mean, those are all statutes. What's that? UCMJ, right? These are all statutes Congress designed to protect individuals from the executive branch, right? And so in that regard, the fact that those were the statutes the administration was flouting was, I think, particularly problematic. Right now, when Congress is passing statutes or otherwise acting in ways designed not necessarily to protect individual rights, right, but just to sort of achieve partisan political victories, or handcuff the administration, or compel the administration to do things hostile to individual rights, right? Like the mandatory military detention provision in the NDAA, right, which the administration didn't want and was the whole basis for its veto threat. You know, I think that's not the same separation of powers question, right? I mean, this is, you know, I think why do we have separated powers, right? We have separated powers to protect individual liberty, not as an end unto itself. And so I think, you know, what the administration really, I think, needs to appreciate, and hopefully will have an opportunity to test over the next 4.5 years, right, is that not all executive power claims are necessarily bad ones, especially if you're claiming that the executive power assertion in that case is necessary to protect individuals from Congress. right? And I think that's the moral high ground the administration hasn't claimed.
And I wouldn't disagree with a lot of what Steve said, other than just to sound the cautionary note that I would be fearful, less so specifically in this administration, but fearful what the presidential value would be of, any assertion by the executive branch, certainly of power against a congressional statute, even if the congressional statute wasn't protecting rights, and even in the kind of Youngstown twilight area. Which is not to say, it shouldn't be asserted by the president if it's in good faith, but just that, we as citizens should treat those assertions with caution, that there almost should be a presumption against them, but the presumption could be rebutted.
I mean, I guess just to illustrate this with an example, right? So let's take a case that's very political but not partisan, right, which is Israel, right? So there's a case the Supreme Court decided last month about whether Congress can compel the executive branch to put on the passport of a U.S. citizen born in Jerusalem that Jerusalem is in fact in Israel. And the reason why that is an issue is because it's been the executive branch's position since 1952 that Jerusalem isn't part of Israel, isn't part of anything, because it's easier that way. Now, here we have an example where the executive's claim is, listen, it's our power to recognize what is and what is not Israel is preclusive.
Zenith, actually.
Right.
Yeah.
I don't think that's, first of all, I don't think that's wrong.
Right. I think that's right.
Right? But second, I also don't think it's hostile. Right? I think that's a great example of Congress, doing something for purely political partisan purposes on an issue that,
Yeah. No, I agree, and in fact, this goes to something I'm working on right now. I agree in that instance. A counter example would be, and I don't know the extent to which the administration has been doing this, but administrations, Democratic and Republican, have been making the following argument. And the following argument is, look, if there is a rights claim based on a treaty, self-executing treaty or a treaty that has been implemented, then and in fact this is what was silently at issue in Hamdan, you courts should defer to our executive interpretation of the treaty, right? And I think at the very least when arms treaties are one thing, but when it is a rights-bearing treaty like the Vienna Consular Convention or the Geneva Conventions as incorporated for the UCMJ, the court should accord zero deference to the executive branch's interpretation, which is exactly what it did in Hamdan, much to the consternation of Justice Thomas.
But isn't that my point? Right?
That is your point. No, I think I'm agreeing with this rights, not rights.
On a point
so.
of agreement. I agree
failed.
about Zlotowski as well. So
We all
okay,
triple
we
failure.
I think identified in the course of the evening some interesting differences, and there are more to be explored. But thank you very much.
Thanks, Don.